सुनवाई को देखने का मकसद ये नहीं है कि हम इसके परिणाम को जाने कि हुआ क्या, चूँकि वो मामला अगली किसी हियरिंग में होगा, मगर ऐसा होता है कि एक लूट हो, उसका सामान हो और वो सामान पुलिस द्वारा आरोपी से जब्त कर लिया गया हो, केस चल रहा हो, और उस स्थिति में जबकि वो सामान कई बार कोर्ट में दिखाया गया हो वगैरह, बावजूद इसके वो माल खाने यानी पुलिस का जो जहाँ पे वो रखते हैं सामान को, वहाँ से वो गायब हो जाए। ऐसी परिस्थिति में जिम्मेदारी किसकी बनती है, लाइबिलिटी? उसमें आप अगर कोई डिपार्टमेंटल इंक्वायरी होती है, उसमें जो व्यक्ति जिम्मेदार पाया जाता है, क्या वो पैसे भरे या सरकार दे? ऐसे कई सारे सवालों को रेखांकित कर रहा है, इसमें उत्तर नहीं है, बट आइए देखिए, ये काफ़ी महत्वपूर्ण है।
Loot. The court, when it was produced before the court directed that it be kept in Malkhana because the criminal trial is pending, and then eventually the criminal trial concluded in the year 2008.
And when did the incident take place?
1988.
1988.
88.
And trial came to an end?
2008.
98, 20 years.
Now,
so for 20 years, the loot was kept in Malkhana.
Because it was used for evidence, so it was brought to the court many a times and then sent back.
And there was an inventory made of loot?
Whatever the process was, it was followed. Now in 2008, the victims, they made an application to the court that the loot valuables be released to them. The court said that you tender a bond of 30 lakhs rupees. They tendered the bond of 30 lakhs. The court directed that the articles be released to them. At that point, it was found that the box in which the articles were allegedly, which contained the articles, was empty, and it didn't have the articles which belonged to the petitioner or which were seized. So the learned district judge, he initiated an inquiry against the Malkhana Nazir. His name was Shankar Lal, who was there at the relevant time, and in the inquiry, it was found that he is guilty. Therefore, an FIR was directed to be registered against him in the year 2017, and on that basis, the criminal trial is pending against him. Now, just two things, my lords. It is true that the valuables are missing. So the court says that, number one, state government should pay 80 lakhs to him, which is questionable because when the question of release of goods were concerned, then the trial court itself said that the bond of 30 lakhs be tendered by the victims because that is what the value was at that time.
That's why I'm asking. That's why I asked you a question. Whether any inventory was made.
Yes, an inventory was made.
And inventory also not only has a description of the articles, but the weight also.
No, not of that kind of inventory. The court says the reason for 80 lakhs the court relies on is that during the process when the seizure is made and then submitted in the court, the police clerk, he gives an estimated value of whatever is being seized by him. So in that somewhere it is written 80 lakhs. So the court says that because it is your own admission that the goods are actually worth 80 lakhs, whereas it was just an ad hoc estimate, which is not of sacrosanct nature. But the court said that on that basis it is 80 lakhs, and so even though the trial is pending, you must pay it. So,
no, whether that assessment of 80 lakhs was a part of the evidence or not?
No. It was just a seizure memo which is placed along with the challan. In that, an ad hoc valuation is done, whatever be whether it be a katta or be a car or be a gold article. But that is not sacrosanct when it comes to compensating a person on that basis. Especially when the trial court itself asked them to give a bond of 30 lakhs only. No? That
will not work because trial court may have said so. But all said and done, how to arrive at the value of it?
Well, this is wrong. To arrive at the value, this process, this reliance placed on this 80 lakhs, which is not by some professional valuer, and it was just a ad hoc estimation given by the clerk. That is wrong. Number one. Number two, when the trial is pending against the suspect and against the accused, then is it not more proper to wait until the trial concludes, and if he is convicted, then the right person to claim compensation would be the accused?
No. See. Why they should wait for the trial to come to an end now? See, this is found proof that loot articles were looted from the complainant the case of loot is found proved. So the articles did belong to complainant. Now, while trial was pending, loot has disappeared. Who has stolen it, who has misappropriated it, you do not know. But you also know the fact that prosecution is launched by the state. This is responsibility of the state to ensure that whatever amount of loot is there is either kept in safe custody or made available as and when trial comes to an end, whether it's a seized vehicle or it's a valuables or whatever you call it. Seizure memo, though prepared by police, but ultimately relied upon by the prosecution.
Not for the purposes of valuation, sir.
May not be, but the seizure memo is relied upon in furtherance of the prosecution's case.
Yes, sir. But
so therefore, liability is that of a state because the loot articles have been misplaced or misappropriated. All that
when the accused person has been found that who has
your liability you cannot deny the liability. Because if the loot articles which were supposed to be returned back to the complainant are not available,
Malkhana Nazir has been found to be guilty in the inquiry,
maybe
departmental inquiry. Which
that,
is the person
that will not absolve you of the liability.
Responsibility of the state, yes, sir.
Liability, not responsibility. Liability.
Eventually, well, it is this person.
Only
but
thing is how much should have been.
My question, yes, sir. This is on a broader aspect of that. Could this be the basis to make me liable? Because it will lead to an unjust enrichment.
Just a minute. What would not be make you liable?
This liable for, could this be the basis?
Now
to
you show me if some valuables are stolen from Malkhana, then where the complaint will go? Now you tell me the law.
No, but the complainant will.
No, you please tell me the law. Who is liable to return it?
I am not saying that government is not responsible and liable. I am saying that this computation of 80 lakhs.
That's why I am saying liability cannot be disputed.
So,
because it has been found to be belonging to the complainant, but now are not available in the Malkhana. Now let us see. The please see this 77 Supreme Court, which is cited by the learned single judge.
Well, in this case, there was no issue of valuation. Valuation was done by the valuer, professional valuer. So
please read para 6 of the judgment, which is quoted here.
It starts from.
It is a common ground that these articles belong to the complainant appellant and had been stolen from her house.
Before that,
it is therefore clear that the articles were the subject matter of an offence. वही जो अपन कह रहे हैं. This fact therefore sufficient to clothe the magistrate with the power to pass an order for return of the property. Where the property is stolen, lost or destroyed and there is no prima facie defence made out that the state or its officers had taken due care and caution to protect the property, the magistrate may in an appropriate case where the ends of justice so require order payment of value of the property. We do not agree with the view of the High Court that once the articles are not available with the court has no power. वो सही है. Supreme Court is right, huh? They may not be, but that's when I see this is what the law is. See, even in this case also, the goods must have been kept in Malkhana. Just let us see that. Coming now to the decision of the High Court, the article questions were never actually produced by the police. So we find that this is factually incorrect. It appears from the finding of the High Court that immediately after articles were recovered by the police and the police submitted a charge sheet to the police, it produced the articles before the court. But the court directed the sub-inspector to retain the property until the same is verified and valued by a goldsmith. For which the court moved authorities for sanction of the necessary funds. The sub-inspector was also directed to bring the goldsmith. In these circumstances. The sub-inspector took back the articles and kept them in the guard room of the police station. It would thus appear that the articles were actually produced before the court but were retained by sub-inspector under the directions of the court. The production before the court does not mean physical custody or possession by the court, but it includes even control exercised by the court by passing an order regarding the custody of the articles. In the instant case, once the magistrate, after having been informed the articles were produced before the court, directed the inspector to keep them within safe custody, to get them verified and valued by the goldsmith. The articles were undoubtedly produced before the court and became custodious. It is a common ground these articles belong to the complainant. अगर मालखाना भी है तो कोर्ट में जब प्रोड्यूस हो गए आर्टिकल, it is kept there, then who will be responsible for it? It does not dispute that. Is only disputing the violation. Do you dispute the liability also?
Not, I am more on the valuation because it's very ad hoc. In a way, it would be unjust enrichment of the party who is there to seek compensation. In this case, there was a goldsmith valuation done. If your lordship could call for the, or I'll place on record the charge sheet, it will make things more clear that how the 80 lakhs, how
FIR में 80 lakhs लिखा हुआ है.
FIR में तो उनकी complaint.
You please see the FIR. Because if we find from page 6 of the impugned order, running page 20, that in the FIR the value is shown to be 80 lakhs.
Version complainant the court has said that
no, you please verify this fact. No.
FIR, the valuation of property as per the FIR was 80 lakh.
Oh.
That is, I will place it on record. That is his complaint that his goods worth of 80 lakhs have gone missing or committed.
Now, whether this fact has come in evidence, I just want to know during the course of the evidence trial, the complainant, whether the complainant was asked this question. What was the value of the articles seized? Because those articles were not produced at the time of trial.
At the time of trial, many times they were brought to the court and then sent back.
So, is there any question related to the value of the articles? Just find out. You find out what is the evidence as regards the value of the articles looted. Whether it forms a part of the record in the form of evidence. If it goes unchallenged, then the situation will be different. Let us see, because you must have produced her in the as a witness. So, what is her evidence in chief, and what was the cross examination?
Yes, sir. I'll place it.
Let us see that part of it also. Then we will take call as regards what is to be done. Let you produce it, you will see that. Shri Modi, after arguing for a while, pressed for time to seek further instructions. List, when do you want it?
After a week.
After a week. And you also find out about the state government circulars. What is the recourse to be adopted in such situations? Because ultimately it's a matter which is indeed affecting the state and with financial liability. So let us see what are the government policy or circulars in the matter of stolen property, from the custody of the police, or for that matter from Malkhana. Yes.
My lords, I am the appellant husband.
You are appellant?
Husband.